Yaroslav. I represent the plaintiff, John Sinan. And the issue before court today is a First Amendment United States Constitution issue. And it's in the violation of a student's free speech in a school setting. And the plaintiff requests that this court to grant its summary judgment and to deny the cross motion of the summary judgment of the defendants. And the motion should be granted on the following reasons. The reason number one, the speech did not create a substantial disruption in the school. And the speech was not vulgar or obscene or offensive, and the speech did not interfere with the pedagogical goals of the school. Now, in order to, would Your Honor like a brief recitation of the facts?
Yes, please.
Okay, in this case, the defendant created a luncheon in which students would gather during lunchtime, and an invited speaker would stand in front of the cafeteria and talk about different issues. In this particular instance, the speaker was talking about the Muslim interactions between the United States and other countries, and this particular issue was, kind of offensive to the plaintiff. And he read the speaker's different papers about the subject, and he just did not agree with what he was saying. So when this occurred, it happened where the speaker, while he came up on the front of the cafeteria, the plaintiff stood up, and he was wearing a jacket. He took off the jacket, and he had a saying that was on the shirt, and he really did not want to offend anyone. He just wanted to express his own viewpoint. At which point he got in front of this podium and showed his T-shirt. And
What did it say?
It said that Jesus rules and Ahmed's God blows, and which means kind of like he's blowing up. And the reason why he put that down there is the fact that the plaintiff was very offended by the fact that the Muslims were blowing up our troops in the Middle East, which was very offensive to him. Now, we believe that the court should grant the plaintiff's motion on the grounds of a tinker, which was the tinker rule, which was determined in a case of Tinker versus Des Moines Independent Community School District, which was resolved in the Supreme Court. And what the Supreme Court decided on was the absence of specific showing of valid reason to regulate the speech. The students are entitled to the freedom of expression of their views. And here, all the plaintiff did was just express his view of his opinion of what was going on, in the case, where the student in Hazelwood was wearing an armband, which was just clothing that just showed his dislike of the Vietnam War. In our case, it's similar because it was just clothing. He did not really have any verbal confrontation or even physical confrontation with anyone else. He just stood up, showed his expression, and that was it. And the same thing, even after the activity, when it ended, the only people that even came up to him were just the people that were, part of the community that was in the Muslim community that were not agreeing with his expression of how he expressed himself during the speech. And also,
wouldn't that be deemed a material disruption under the Tinker standard so that the school could restrict it?
Well, under the Tinker standard, it would have been a material disruption, except here, when the plaintiff stood up, in front of the speaker. He sat down, and there was no evidence of any disruption in the cafeteria. The speaker kept, with his speech. He said everything that he wanted to speak. And, the students were not, in an uproar, or they did not incite any kind of riot of any what that could have occurred, which was where the Supreme Court actually said that under that standard, if you would have a specific, goal of limiting a riot or any kind of uprising, then the school has the grounds for it. Here, you had only 4 people approach the plaintiff at the end of the cafeteria, and as a matter of fact, he took off the shirt right before the next period of the school, which I'll continue in the next point. We believe that we will still win, and we should be granted this motion under the Hazelwood standard, which was made in the Hazelwood School District versus Kohlmeyer, which was also resolved in the Supreme Court. And there was what happened in that particular case was these students were writing in the newspaper, in the journal, and there's a distinction between our case and this particular case of Hazelwood, because in Hazelwood,